Audit them, your favorite auditor, the one who encourages you to audit them. Late night special statute reading. Just waiting for a few more people to get in here. And audit them, your favorite auditor, the one who encourages you to audit them. Yep, we are live. Perfect. Alrighty, so let's see what we got here. We're going to the Illinois compiled statutes, and we're going to look through the civil procedure, code of civil procedure. Hey Jay, how's it going? So when we open up civil procedure, we zoom in and let's see what we got here. General provisions, civil procedures, venue, process. Alrighty. Process, appearance, parties, appointment of guardians, pleading, action for declaratory judgment, class action, action on penal bond, pre-trial steps. Alrighty, let's see. Mandatory arbitration system, trial, post-trial, judgment, post-judgment. What's that? Abolition of writs. Abolish writs. Revival of judgment. Healing art malpractice. Mittimus. Lis pendens, crime victims, product liability, Part 22, insurance placement liability, settlement 23, Article 3, administrative review, attachment in general, watercraft costs, ejectment, eminent domain, repealed evidence. And evidence has many parts to it. Interested person as witness. Dead Man's Act, surviving partner or joint contractor, account books and records, effect of release or assignment. Certain laws unaffected, Part 7. Broadcast or televised testimony. Privileged communication, reporters privilege, voters privilege, interpreter privilege, Part 10, judicial notice. Oh wow. Part 11, statutes and reports. Part 12, records and patents, surveys, interpreters, proof of handwriting, proof of deed and writings, title to land of Illinois Central Railroad, claims regarding work on realty, admission of liability, Part 19, Part 20, inspection of records, Part 21, medical studies, coroner records, perpetuating testimony, perpetuating testimony, application to criminal cases. Let me zoom out here. Well, right now we're doing a quick reading on the actual subsections, and we're gonna get into a reading shortly. So let me zoom in here. Or is there anyone that you're interested in, Jay? So we were at application of criminal cases, expert witness standards, Part 26, minors, Part 27, elder adults, Part 28, prior sexual activity or reputation as evidence, Part 29, immigration status, eviction, in general, recovery of rent, termination of certain tentacles, distress for rent, habeas corpus, injunction, in general, disbursement of public monies, Part 3. Alrighty. I know which one we're going to get into right now. So, judgments, enforcements, trial of right of property. Part 3 is concealing property. Wow. Part 4, redemption by state. Part 5, federal judgments. Part 6, foreign judgments and foreign money claims. Part 7, garnishment. Part 8, wage deductions, exemptions of homestead, exemptions of personal property, garnishment in violation of exemption, exemption in bankruptcy, orders to take into custody. Limitations. Part 1, real action. Part 2, personal actions. Mandamus, mortgage foreclosure, general provisions, definitions. Let's see here. Mortgage of lists or lien priorities, methods of terminating mortgagors' interest in real estate. Judicial foreclosure procedure. Reinstatement and redemption, possession during foreclosure, exit, partition, quo warranto replevin, effective date, recovery of fraudulently obtained public funds, change of name, and frivolous lawsuits filed by prisoners. Frivolous lawsuits filed by prisoners. Alrighty. So with that being said, we're going to open up a box here, and it's going to be, if anybody could guess, they'll get a virtual cheeseburger, but it's going to be, where was it at? Let's see. Here it is. Alrighty. Let me look at the comments before we get into it. Is there anything in particular? Yep, we're on it now. So, who's this? Go to channel. There's new videos. Yeah, there's new videos. So we are going to open up the new packet here. I don't have any in particular. I think for the future we need to read up on the immigration laws and evictions and foreclosure procedures. I think things are going to get worse before they get any better. Well, what exactly are you referring to? So we're going to open up part 10, judicial notice. Judicial notice. This is about a two-page reading. So let's see here. Let me zoom in. Alrighty. Judicial notice. Let's see what this is here. 735 ILCS 58101. Oh, right. Courts of original jurisdiction. Every court of original jurisdiction, in addition to the matters of which courts, or let me highlight for you guys, of which courts of original jurisdiction have heretofore been required to take judicial notice. Again, courts of original jurisdiction. Every court of original jurisdiction, in addition to matters of which courts of original jurisdiction have therefore been required to take judicial notice, shall take judicial notice of the following: all general ordinances of every municipal corporation within the state. Oh shit. All general ordinances of every municipal corporation. That's about 8,000. All ordinances of every county within the state. So every general ordinance and all ordinance, all laws of a public nature enacted by any state or territory of the United States, all rules of practice in force in the court from which a case has been transferred by change of place of trial or otherwise. Courts of appellate jurisdiction. 735 ILCS 58-1002. Courts of appellate jurisdiction. Upon the review by any court of appellate jurisdiction of a judgment or order of a circuit court, the court of appellate jurisdiction shall take judicial notice of all matters of which the circuit court was required to take judicial notice, including all rules of practice adopted by the circuit court. In case of the review by the Supreme Court of a judgment or order of the appellate court, the Supreme Court shall take judicial notice of all matters of which the circuit court was required to take judicial notice, as well as of the rules of practice adopted by the circuit court, the judgment or order of which has been reviewed by the appellate court. 735 58-1003. Common law and statutes. Every court of the state shall take judicial notice of the common law and the statutes of every state, territory, and other jurisdiction of the United States. 1004. Information of the court. The court may inform itself of such laws in a manner as it may deem proper, and the court may call upon counsel to aid in obtaining such information. 735 ILCS 58-1005. Ruling reviewable. The determination of such laws shall be made by the court and not by the jury, and shall be reviewable. 6. Evidence as to laws of other jurisdictions. Any party may also present to the trial court any admissible evidence of such laws. Let's read this one over. Evidence as to laws of jurisdictions. Any party may also present to trial court of any admissible evidence of such laws, but to enable a party to offer evidence of the law in a matter in another jurisdiction, or to ask the judicial notice to be taken thereof, reasonable notice shall be given to the adverse parties, either in pleadings or otherwise. Foreign country, Section 7. The law of a jurisdiction other than those referred to in Section 8-1003 of this Act shall be an issue for the court, but shall not be subject to foregoing provisions concerning judicial notice. 1008. Interpretation, Section 10-1003, 8 through 8-1007 of this Act shall be so interpreted and construed as to effective its general purpose, or effectuate its general purpose, to make uniforms the law of the state which shall enact it. Yeah, let me read this one over. Interpretation, Sections 8-1003 through 8-1007 of this Act shall be so interpreted and construed as to effectuate its general purpose, to make uniform the law of those state which enact it. Okay, we're going to have to refer back to Section 3 and 7. So here's 7, foreign country, and 3 was common law. Okay, let's go ahead and carry on. Short title of the Uniform Act. Like I said, people might think, oh, this shit is boring. This is boring. But at the same time, you got to stay informed, man. You got to keep informing, being informed. Uniform Act sections. This act may be cited as the Uniform Judicial Notice Foreign Law Act. Alrighty, let's see what else we have on the pressure cooker. So here's the whole spindle here. Here's the whole spindle. Yeah, let's do a quick scroll through, see what else we have here on the supply list. Alrighty, so that's civil procedure. Let's go back here. Citizen Participation Act. Let's see what that is. Alrighty, let's see what this is, guys. Here we opened up a couple pager. This one is Citizen Participation Act, 735 ILCS. This one rings a bell. 735 ILCS 110.5, public policy pursuant to the fundamental philosophy of the American constitutional form of government. It is declared to be the public policy of the state of Illinois that the constitutional rights of citizens and organizations to be involved and participate freely in the process of government must be encouraged and safeguarded with great diligence. The information, reports, opinions, claims, arguments, and other expressions provided by citizens are vital to the effective law enforcement, the operation of government, the making of public policy and decisions, and the continuation of representative democracy. The laws, courts, and other agencies of the state must provide the utmost protection for the free exercise of these rights of petition, speech, association, and government participation. Damn, that's another one. Woo, man. We found two, what you folks call bangers. So with that being said, let's take an image. Everybody screenshot this highlight. We're going to have to read this one over again with emphasis. Man, we found two. Look at these words here. Well, the first sentence on this is from the FOIA Act, first paragraph of the FOIA Act. But they retweaked it. Let me see here. Alrighty, 735 ILCS 110.5, Public Policy. This is under the Citizen Participation Act, right? And this says, public policy pursuant to the fundamental philosophy of the American constitutional form of government. It is declared to be the public policy of the state of Illinois that the constitutional rights of citizens and organizations to be involved and participate freely in the process of government must be encouraged and safeguarded with great diligence. The information, reports, opinions, claims, arguments, and other expressions provided by citizens are vital to effective law enforcement, the operation of government, the making of public policy and decisions, and the continuation of representative democracy. The laws, courts, and other agencies of this state must provide the utmost protection for the free exercise of these rights of petition, speech, association, and government participation. I'm going to have to memorize this, but let's go ahead and carry on here. Civil actions for money damages have been filed against citizens and organizations of the state as a result of their valid exercise of their constitutional rights to petition, speak freely, associate freely, and otherwise participate in and communicate with government. There has been a disturbing increase in lawsuits termed strategic lawsuits against public participation in government or such slaps. Look at that. As they popularly call the threat of slaps, significantly chills and diminishes citizens' participation in government. Man, this shit is so strong. You guys don't know. Voluntary public service and exercise of these important constitutional rights. This abuse of the judicial process can and has been used as a means of intimidating, harassing, or punishing citizens and organizations for involving themselves in public affairs. It is the public interest and it is the purpose of this act to strike a balance between the rights of the persons to file lawsuits for injury and the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government. That's what I do on the daily. I participate with government, in government, right? So the to protect and encourage public participation in government to the maximum extent permitted by law, to establish an efficient process for identification and adjudication of slaps, and to provide for attorneys' fees and costs to prevailing movants, people who move the court. This is unbelievable. Alrighty, let's go ahead and continue. Definitions. Government includes a, look at how strong this is. Government includes a branch, right? A department, an agency, instrument, official, employee. Government means an employee or agent or other person acting under color of law of the United States. And you guys say, oh, audit them, he's he's updating his clipboard. Yeah, audit them is updating his clipboard. So government, this is the definition of government in the actual Participation Act, which is cited as 735 ILCS 110 Citizens Participation Act. Definition to government includes a branch, department, agency, instruments, official, employee, agent, or other persons acting under the color of law of the United States, a state, a subdivision of a state, or another public authority, including the electoral. All right, let's carry on. Person include an individual, corporation, association, organization, partnership, two or more persons having a joint or common interest, or other legal entity. Go ahead and continue. Judicial claim. Judicial claim or claim include any lawsuit, cause of action, claim, cross claim, counterclaim, or other judicial pleading or filing alleging injury. We got to look up cross claim. Motion includes any motion to dismiss, for summary judgment, or to strike, or to any other judicial pleadings filed in dispose of judicial claim. Moving party means any person whose belief a motion described in subsection A of section 20 in filed seeking dismissal of judicial claim. Responding party means any party against whom a motion described in subsection A section 20 is filed. Alrighty, 735 ILCS 110-15 applicability. This act applies to any motion to dispose of claims in a judicial proceeding on the grounds that the claim is based on, relative to, or is in response to any act or acts of the moving party in furtherance of the moving party's rights of petition, speech, association, or to otherwise participate in government. Acts and furtherances of the constitutional rights to petition, speech, association, and participation in government are immune from liability regardless of intent or purpose, except when not genuinely aimed to procuring favorable government action, result, or outcome. Damn! That's a good one. Let's take a screenshot. That's unbelievable, man. There's so much good knowledge out there, guys. You just gotta read through it, really. We're gonna have to do a reading. Well, let's continue let's continue. Motion 735 IOCS 110-20. Motion procedure and standards. A. On the filing of any motion as described in Section 15, a hearing and decision on the motion must occur within 90 days after notice of the motion is given to the respondent. An appellate court shall expedite any appeal or other writ, whether interlocutory or not, from a trial court order denying that motion or form a trial court failure to rule on that motion within 90 days. Okay, this is now something that I gotta read through a few times, but within 90 days after the trial of the court or failure to rule. Section B. Discovery shall be suspended pending a decision on the motion. However, discovery may be taken upon leave or leave of court for good cause shown on the issue of whether the movements acts are not immunized, or what's this? Immunized, right? Immunized from, or furtherance of acts immunized from liability of this act. The court shall grant the motion and dismiss the judicial claims unless the court finds that the respondent party has produced clear and convincing evidence that the acts of the moving party are not immunized from or are not in furtherance of acts immunized from liability by this act. Section C. Alrighty. 735 ILCS 11025, attorney fees and costs. The court shall award moving party who prevails in a motion under this act reasonable attorney fees and costs incurred in connection with the motion. Damn, that's another good one. Let's take a digital image. Okay. Construction of act, section 30, part A. Nothing in this act shall limit or preclude any rights the moving party may have under any other constitutional, statutory, case or common law or rule provision. B. The act shall be construed liberally or effective its purpose and intent fully. Liberally. Alrighty. Servability. The provisions of this act are servable under sections 1.31 of the statute on statutes. Yeah. Effective date. This act shall effect upon becoming law. Okay. Source: Public Act 95-506, effective 07. Alrighty, this one was amazing, man. I'm glad we stumbled on this because the first paragraph of this, the first couple 2-3 paragraphs of this is impactful. It really is. So let me zoom in here and take a screenshotter. Wow, that was amazing, man. Alrighty, and let's go ahead and carry on here. Public policy. Pursuant to the fundamental philosophy of the American constitutional form of government, it is declared by the public policy of the state of Illinois that constitutional rights of citizens and organizations to be involved and participate freely in the process of government must be encouraged. It must be encouraged and safeguarded with great diligence. The information, reports, opinions, claims, arguments, and other enforcement, the operation of government, the making of public policy and decisions, and the constitution of representative democracy. The laws, courts, and other agencies of the state must provide the utmost protection for the free exercise of these rights of petition, speech, association, and government participation. Man, I'm going to memorize that, and I'm going to start yelling at the officer. Not yelling, but, you know, speaking with devotion, you know, or let me go ahead and carry on here. That one was amazing, man. That's under the civil procedure. Alrighty, so let's see what other items we have here. Choice of Law and Forum Act, removal of Private Compromising Image Act. Let's see, Choice of Law and Forum Act. View entire act. What is this? Alrighty. 735 ILCS 1055-5, Section 555555. Choice of law. Speaking with a sure authority, knowledge. Alrighty. Section 5.5. The parties to any contract, agreement, or undertaking, contingent or otherwise, in consideration of or relating to any obligation arising out of a transaction covering in the aggregate not less than 250,000, including a transaction otherwise covered by subsection 1 of section 1-105 of the Uniform Commercial Code, may agree that the law of the state shall govern their rights and duties in whole or in part, whether or not the contract, agreement, or undertaking bears a reasonable relation to this state. This section shall not apply to any contract, agreement, or undertaking. Undertaking is a job description. For labor or personal services relating to any transaction for personal, family, or household services, or to the extent provided in contrary to subsection 2 of this Uniform Commercial. Nothing contained in this subsection shall be construed to limit or deny the enforcement of any provision respecting choice of law in any other contract, agreement, or undertaking. Okay, that's cute. Choice of form. 735 ILCS 105 section 510. Any person may maintain an action. This is choice of forum. Any person may maintain an action or proceeding against a foreign corporation not resident or foreign state if the action or proceeding arises out of or relates to any contract, agreement, or undertaking for which choice of Illinois has been made in whole. Alrighty, this one, let's just go ahead and carry on here. Let's see what else we have on the slip. Let's see what else we have on the supplies list. Alrighty. Well, alrighty, let's see what this is right here. This is removal of Private Compromising Image Act under 735 ILCS 115. Definition. Image. Image has the meaning provided in subsection A of the section 1-23.5 of the Criminal Code of 2012. Inmate, or what's this? Intimate parts has the meaning of provided in subsection of the Criminal Code. Alrighty, section 10, 735 ILCS 115.10. Posting of private, listen to the word, of private compromising images. A person shall not post a private comprising image of another person online. A person posts a private compromising image when he or she, number one, intentionally disseminates an image of another person who is at least 18 of age, who is identifiable from the image itself or the information displayed in connection with the image, and whose intimate parts are exposed in whole or in part, and whose, okay, that's number two, obtains the image under circumstances in which a reasonable person would know or understand that the image was taken without the person's knowledge or consent, and knows or should have known that the person in the image has not consented to the dissemination, or owns or operates a website on which the posting of private compromising images, right, is allowed or not removed upon discovery of such images being posted. Takedown order. A person may file a petition for a takedown order if the person discovers that a private compromising image of him or herself is posted online. Section B. If at the time of the hearing for a takedown order the court finds that the defendant posted a private compromising image, then the court shall enter a takedown order, and the defendant shall immediately delete or remove the private compromising image from the website. Emergency takedown order. Upon the return of service date, if the plaintiff presents a prima facie evidence that the image at times is private compromising image of the plaintiff, the court shall enter an emergency takedown order without a hearing to have the image removed from the website immediately. Damages. A person who found to have posted a private compromising image of another person by court shall be liable for damages. The amount of damages shall be at the discretion at the court. Liability. 735, Section 30. Nothing in this act shall be construed to impose liability on an interactive computer service as defined in 47 U.S.C. 230 F2 for content provided by another person. Alrighty, amazing. Quick analysis, no problem. Let's see what else we have on the agenda. Alrighty, let's go back to the chamber. We are back on chamber here. We did a quick analysis of the civil procedure. No problem. No problem. Now, what else do we have here? Trusts and fiduciaries. Alrighty. Trustee Surety Release Act. Trustee Surety Release Act. Let's see what this is. 735-85-1. Trustee Surety Release Act. Whenever any surety on the bond of any trustee of any fund or property appointed to be by at last will or other instruments in writing, or appointed or created in any other manner than by appointments by the court or any here executor or administrator, such surety desires to be released from the further liability on such bond, he or she may file an action for that purpose in the circuit court against such trustee and all other persons interested in such fund of property, including any other surety or sureties upon such bond, setting forth the facts relating to such bond and praying for the release of such surety. The practice in such action shall be the same as near as may be, as in other civil case, and the court shall have power to compel such trustee within such reasonable time as may be fixed by court for that purpose. Alrighty, well, yeah, that's neither here nor there. Alrighty, let's see what else we have. Let's open up the packet here. Alrighty. Judicial proceedings, duties and powers of trustee. Yeah, this is a good one for later reading. Creation, validity, modification, and termination of a trust. Dang. Yeah, surety, right, insurance. We read that the other night. That might have been in that same packet, bro. Article 4, creation, validity, modification, and termination of trust. Wow. Yeah, this is about a 4 or 5 page. Methods of creating a trust. A trust may be created by transfer of property to another as trustee during the settler's lifetime, or by will, or by disposition taking effect on the settler's death. Declaration by the owner of property that the owner holds identifiable property as trustee. Number 3. Hey, T-Dotter, you came right on time, bro. This is creation of a trust. Declaration by the owner of the property that the owner holds identifiable property as trustee. Number 3. Exercise of power of appointment in favor of a trustee. Order of a court or exercise by an authorized fiduciary of the powers. Requirements for creation. A trust is created only if the settler or other person creating the trust has capacity to create a trust. The settler or other person creating the trust indicates an intention to create the trust. Number 3, the trust has a definite beneficiary or is a charitable trust, be a trust for the care of an animal as provided in section 408, or C, a trust for a non-charitable purpose as provided in 409. Number 4, the trustee has duties to perform, and number 5, the same person is not the sole trustee and sole beneficiary. Alrighty. A beneficiary is definite in the beneficiary can be ascertained now or in the future, subject to any applicable rule against perpetuities. C, a power in trustee to select a beneficiary from an identifiable class is valid. If the power is not exercised within a reasonable time, the power fails and the property subject to the power passes to the person who would have taken the property had the power not been conferred. Alrighty, this is something we'll have to scribble through at a later time. Yeah, this is a good one though. So creation, validity, modification, and termination. Alrighty, let's see what else we have here. We are under fiduciaries and trusts. Office of Trustee, Total Return Trust, decanting, trust decanting, decanting power. Let's define that. Or the decanting power means the power of an authorized fiduciary under this article to distribute property of a first trust to one or more second trusts, or to modify the terms of the first trusts. Slapped. Yeah, man, that was a fucking good reading. The Participation Act. Man, that one was a huge one. That one and the other one, government corruption, the reading that I did yesterday. Those two paragraphs. Alrighty. Let's see what else we have on the agenda. Excuse me. Expanded distribution discretion. Alright, so yeah, I just wanted to define decanting power. Let's see what else we have here. Illinois Prudent Investor Law, life insurance affiliated investments. Let's see. A trustee has a duty to invest and manage trust assets as a prudent investor would, considering the purpose, terms, distribution requirements, and other circumstances of the trust. This standard requires the exercise of reasonable care, skill, and caution, and applies not in isolation, but in the context of the trust portfolio as a whole and as a part of the overall investment strategy. Yep, that incorporates risk and return objectives reasonably suitable to the trust. Oh, good to know. Hey CJ, how's it going? So let's skim. Yeah, let's skim. So this is under, let's go back to the chamber. Here we're back in the chamber. Alrighty. Now you have property at 765. Okay. Conveyance Act as the main meal ticket. Here's property. Here you have real property. Here you have plats and surveys. Here you got future investments. Future interests. Here you got land trusts, mineral rights, condominiums, landlord and tenants, cemeteries, mortgages, miscellaneous property. So let's say here you have Employment Patent Act, Illinois Trade Secrets Act, Right of Publicity Act. Right of Publicity Act. Okay, yeah, we could skim through this at a later time. What else do we have? So we have real property. Conveyance. Let's see. Installment of, what's that? Torrens repeal. You remember that one? Water Dam Use Act, Commission Interest, Homeowners Energy Policy Statement Act. Oh shit! Homeowners Energy Policy Statement Act. Let's see what this says. 765 IOCS 165-1. This act may be cited as the Homeowners Energy Policy Statement Act. Imagine the energy company has to tell you things they don't. And then since they don't, there's, well, let's read through it. This looks like maybe a 4 or 5 pages. Let's see what the first thing says here. Legislative intent under 165.5, Section 5. Legislative intent in enacting this act is to protect the public health, safety, and welfare by encouraging the development and use of solar energy systems in order to conserve and protect the value of land, buildings, and resources by preventing the adoption of measures which will have the ultimate effect. However, unintended of preventing the use of solar energy systems of any home that is subject to homeowners association common interest commonly. Alrighty. Solar. Neither here nor there. Alrighty. So under plats you have Illinois Coordinate System Act. Man, when you start reading stuff like this, it opens you up into a new FOIA inquiry. Let's see. Yeah, Department of Commerce, United States. Alrighty, neither here nor there. Let's see, back here. Let's see, future interests. Power of appointment, termination of power, act, surrender or merger of reversion act, contingent remainder act, Doctrine of Worthier Title Abolishment Act. Sounds like they're playing Mortal Kombat. You know you're in mono, right? What do you mean, my vocals? My vocals is in mono? Yeah, I got one mic. I'm speaking into a condenser through an XLR into a audio interface. Well, the settings, being that it is one mic, I think the settings has it in mono, if that's what you're referring to. Or you're talking about my deep voice being mono. Okay, so here we are at 735. What is this? Doctrine of Worthier Title Abolishment Act 765 IOCS 351, where a deed, will, or other instrument purports to create any present or future interest in real estate or personal property in the heirs of the maker of the instrument, the heirs shall take by purchase and not by descent the interest that the instrument's purpose to create, the doctrine of worthier title, and the rule of common law that a grantor cannot create limitation in favor of his or her heirs are abolished. Alrighty, this act shall apply only to instruments which have become effective after the date of this act. Neither here, neither. Those are cool words, but you know. Doctrine of worthier Title Abolishment Act. Alrighty. Yeah, like some of those one paragraphers are pretty cool. Land Trust Duties Act, Mining Act, Minerals, Drilling Operations, Coal Rights, Oil and Gas Lease, Condo, Landlord, Property Taxes of Non-Citizen Landlords Act. Property Taxes of Non-Citizens Landlord Act. Let's see this. Section 765 ILCS 725. Section 1. No contract, agreement, or lease in writing or by parole, by which any lands or tenements therein are demised or leased by any non-citizen or his agent for the purpose of farming, cultivation, or other relating groups crop therein shall contain any provision requiring that the tenant or other person for him to pay taxes on said lands or tenements or any part of thereon. All are such provisions, agreements, and leases so made are declared void as to the taxes aforesaid, if any non-citizen landlord or his agents shall receive in advance or any other time or sum of money or article of value from any tenant in lieu of such taxes, directly or indirectly, the same may be recovered back by such tenant before any court or having jurisdiction of the amount thereof. Any all provision of agreement in writing or otherwise to pay such taxes shall be held in all courts of the state to be void. Might have to read that again at a later time. Alrighty. Well, let's go back to the chamber. Here we are in the chamber. Human rights. Alrighty, anyhow. Yeah, did a couple readings, no problem. Education. Thank you guys for watching. The one who encourages you to audit them.